We have a warrant to search this property. Step aside.
Warrant?
They don't have to show you anything. We're executing a lawful search.
Actually, under the Fourth Amendment, you're required to present the warrant before entry.
Lady, you're interfering with...
And conducting a warrantless search is a constitutional.
Nothing about the doorway looked dangerous. The officer stood close enough to block it, close enough to control the exchange with a single request. A name, identification, compliance. It was routine. It always is. The kind of moment that never appears in reports until much later. Inside the house, nothing was being hidden. Outside, authority believed it already knew the outcome. This was not a raid, not a warrant, not an emergency. Just a decision made in seconds, recorded quietly, and misunderstood by the person making it. At that moment, the law did not collapse. It began to take notes. Careers do not end all at once. They end when a small action crosses a line that cannot be uncrossed. The investigation would come later. So would the sentence. The mistake had already happened. The only question left was the cost. The knock was firm but unremarkable, not urgent, not aggressive. The kind of knock that assumes compliance before it is given. When the door opened, the officer did not step back. He stepped forward, just enough to claim the threshold. His voice carried the confidence of routine authority, the tone used when outcomes are assumed rather than assessed. A request for identification followed, then another, each framed as procedure, each narrowing the space for choice. Nothing illegal was visible. No threat was present. The setting remained unchanged, calm, domestic, ordinary. Yet the posture of the encounter shifted. The officer's questions stopped gathering information and began directing behavior. Control was no longer implied. It was asserted. Inside the house stood a federal judge. Outside stood a patrol officer who did not know that fact and did not ask the questions that would have revealed it. The law had not yet been violated, but it was being tested. What followed was not a sudden abuse of power, but a sequence of small decisions, each one defensible in isolation, each one recorded, each one moving closer to a boundary that exists precisely for moments like this. By the time the officer raised his voice, the record was already forming. By the time he issued the next command, the outcome was no longer flexible. Inside the home was a life defined by restraint rather than spectacle. The kind of life built over decades without incident, without controversy, and without the need for attention. The woman standing just behind the doorway had spent her career evaluating evidence, weighing credibility, and enforcing constitutional limits on power. She was a federal judge, appointed after years of service within the justice system, known for her methodical approach and absence of public scandal. Her professional record reflected consistency. She presided over complex criminal cases, ruled on civil rights claims, and issued opinions that shaped how law enforcement conduct would later be judged. In court, her authority came not from volume or force, but from precision. Lawyers prepared carefully before appearing in her courtroom. Prosecutors measured their arguments. Defense attorneys trusted that procedure would be followed exactly as written. Outside of work, her life was deliberately unremarkable. A private residence in a quiet neighborhood. Predictable routines. No prior confrontations with law enforcement. No history that would suggest volatility or risk. Neighbors knew her as reserved, reliable, present, but not conspicuous. On that evening, she had done nothing to invite scrutiny. She had not called for assistance. She had not stepped into public space. The encounter was not the result of a complaint, a warrant, or an observed violation. It began because an officer chose to initiate contact and believed that doing so required no explanation beyond uniform and badge. This distinction matters, not because of her title, but because of what it represents. A person whose career depended on respecting constitutional boundaries understood exactly where they were drawn. She understood when compliance was required and when it was optional. She understood the legal weight of a request framed as an order. At the doorway, she did not raise her voice. She did not threaten. She did not resist. She asked for clarification. She sought to understand the basis for the intrusion. The questions were calm, procedural, and measured. The kind routinely asked in courtrooms across the country. From the officer's perspective, none of this was visible. He saw a black woman inside a private residence who did not immediately comply. He did not see her professional history. He did not recognize the posture of someone trained to evaluate authority rather than submit to it without cause. That gap between perception and reality would soon matter, not because of who she was, but because the system she served was about to evaluate the encounter using the same standards she had applied to others for years. At that threshold, the law was still intact. It had not yet been crossed, but it was being approached. Before the knock, nothing distinguished the evening from any other. The house was quiet, the neighborhood unchanged. There was no emergency unfolding, no report of violence, no indication that police presence was required. The moment existed entirely within the boundaries of normal life. When the officer arrived, he did so without urgency. No lights, no sirens, no call demanding immediate action. His approach suggested discretion, not danger. This was not a response to a crime in progress. It was a discretionary contact, initiated without visible cause. The judge answered the door as any resident would. She remained inside her home. She did not step onto the porch. She did not cross into public space. The boundary between private and public was intact, clearly marked by the threshold beneath her feet. The initial exchange was brief, a greeting, a request. Nothing in her demeanor suggested hostility. Nothing in the environment suggested risk. The questions she asked were neutral and procedural. Why are you here? What is this? Regarding, am I being detained? These were not challenges. They were clarifications. From the outside, the scene would have appeared unremarkable. Two people speaking calmly at a doorway. No raised voices. No visible conflict. No gestures that would later justify escalation. The officer had time, space, options. This was the last moment when the encounter could have ended cleanly. At this stage, the law offered clear guidance. Without a warrant, without exigent circumstances, and without probable cause, the officer's authority stopped at the threshold. Requests could be made, compliance could be sought, but refusal carried no penalty. The judge understood this. Her posture reflected it. She remained still. She spoke evenly. She did not invoke her title. She did not attempt to assert status. She relied only on the rules that govern every citizen equally. The officer did not articulate a reason for the contact. He did not explain what he was investigating. He did not indicate that she was suspected of wrongdoing. Instead, he repeated the request, this time with less patience. Nothing had yet gone wrong. No rights had been violated. No unlawful order had been issued, but the balance had begun to shift. What started as a voluntary interaction was quietly transforming into something else. The normalcy of the moment made what followed possible. Because when everything appears calm, escalation feels justified. And when escalation feels justified, boundaries are crossed without being noticed. The law still allowed a pause. It would not last. The shift did not arrive with force. It arrived with tone. The officer's posture changed first. His stance widened slightly, feet planted as if the exchange now required control rather than conversation. The requests, once framed as questions, began to lose their conditional language. Identification was no longer being asked for. It was being expected. He repeated himself, slower this time, louder. Each repetition carried an implication that refusal was no longer an option, even though nothing about the circumstances had changed. No new information had emerged. No threat had appeared. No legal threshold had been crossed. Only patience had worn thinner. The judge remained inside her home. She did not retreat, but she did not advance. She asked again what the basis was for the demand. The question was precise. It sought justification, not confrontation. In court, such a question would have been routine. At the doorway, it was treated differently. The officer did not answer it. Instead, he invoked procedure without explanation. He referenced policy without naming it. He suggested consequences without defining them. This is how authority expands when it is not challenged by evidence. The language becomes vague. The commands become firmer. The reasoning disappears. What followed was a sequence of decisions, each small enough to appear defensible on its own. A refusal to explain became irritation. Irritation became suspicion. Suspicion became an assumption of non-compliance. None of these steps required violence. They required only the belief that authority did not need to justify itself. The officer instructed her to step outside. She declined, calmly, lawfully. Remaining inside her home was not resistance. It was a constitutional right. But the distinction mattered less to the officer than the fact that control had not been granted. His voice rose again. The words changed. Where requests had once been framed as procedural, they were now framed as warnings. Failure to comply, obstruction, detention. Each term carried legal weight even when applied incorrectly. The judge responded by asking whether she was being detained. It was a critical question, one that requires a clear answer under the law. An answer that defines the boundary between voluntary cooperation and compelled compliance. The officer did not answer that either. Instead, he stepped closer. Close enough that the threshold was no longer a neutral line. Close enough that the encounter began to feel physical without any contact being made. The space narrowed. The options narrowed with it. At this point, the escalation was no longer accidental. It was procedural. The officer had committed to a path that assumed authority first and justification later. Every moment that passed made reversal less likely, not because it was impossible, but because it would require acknowledging error. The judge remained composed. Her voice did not rise to meet his. She did not invoke her position. She did not threaten legal action. She relied on the same restraint she had demanded of officers from the bench. The irony was complete, even if unrecognized. The officer announced that he was conducting an investigation. He did not specify into what. He suggested that her refusal to comply was itself suspicious. This circular logic transformed a lawful exercise of rights into a justification for further intrusion. He reached for his radio, not to call for backup in response to danger, but to solidify authority through presence. Additional units would mean witnesses. It would also mean momentum. At no point did the situation become unsafe. At no point did the judge pose a threat. The escalation was driven entirely by perceived defiance, filtered through assumptions that had nothing to do with the law and everything to do with control. This is how unlawful detentions begin, not with chaos, but with certainty, not with violence, but with procedure misapplied. Each step framed as necessary, each step recorded. When additional officers arrived, the dynamic shifted again. The original assumptions hardened into consensus. The presence of others reduced the likelihood of reconsideration. Authority, once shared, becomes harder to retract. The judge was informed that she was now being detained. The basis remained unclear. The explanation remained absent. What had begun as a discretionary contact had crossed into compulsion without justification. The law had not failed loudly. It had been overwritten quietly. And by the time the officer issued the next command, the record was no longer neutral. It reflected a version of events shaped by authority rather than fact. A version that would later be tested, line by line, against evidence that did not bend. The escalation was complete. The consequences were now inevitable. By the time the word detention was used, the encounter had crossed a boundary the law treats as decisive. Until that point, the interaction could still be framed as voluntary. After it, every action required legal justification that had not been articulated. This distinction is not semantic. Under constitutional standards, a detention occurs when a reasonable person would no longer feel free to ignore the officer and end the encounter. Tone, proximity, repeated commands, and the presence of multiple officers all matter. At the doorway, those factors had accumulated gradually, not suddenly, but their combined effect was unmistakable. What had not changed was the absence of cause. No crime had been reported involving the judge. No exigent circumstances existed that would justify immediate action. No warrant had been obtained. The officer's authority did not extend beyond request and conversation. The moment he converted refusal into suspicion, the logic inverted itself. This is a common error. Officers are permitted to ask questions. Citizens are permitted to decline. The refusal itself cannot supply the justification that was missing before it occurred. When it does, the encounter becomes circular, and the law no longer supports it. Another boundary was tested when the officer demanded identification. In many jurisdictions, identification can only be compelled during a lawful detention based on reasonable suspicion of criminal activity. Without that foundation, the request remains optional. Framing it as mandatory does not make it so. The judge's responses remained consistent. She did not obstruct. She did not interfere with an investigation because no investigation had been defined. She asked questions that required answers under the law. Each time those answers were withheld, the legal footing weakened. The escalation also revealed a procedural failure that would later matter. Once additional officers arrived, no one reassessed the basis for the detention. No supervisor intervened to clarify the justification. Momentum replaced analysis. The presence of multiple uniforms created the appearance of legitimacy without supplying its substance. This is where the system becomes visible, not as a single decision, but as a series of missed corrections. Each officer deferred to the assumption that someone else had already established cause. No one did. The location mattered as well. The encounter occurred at the threshold of a private residence. The law treats that boundary with heightened protection. Absent a warrant or exigency, authority does not cross it. Commands issued from outside do not acquire force simply because they are repeated. At no point did the officers articulate a lawful basis for extending control into that space. Yet control was asserted anyway, not through force, but through persistence, not through violence, but through procedure applied without limits. From a legal perspective, the record was already compromised. Statements made after an unlawful detention carry different weight. Actions taken without authority do not become lawful retroactively. The fact that the judge remained calm did not legitimize what followed. It preserved it. These checkpoints exist to prevent exactly this outcome, to ensure that authority remains conditional, not assumed. When they are ignored, the consequences do not appear immediately. They arrive later through review, testimony, and evidence that does not change its account. At the doorway, the officer believed he was maintaining control. In reality, he was documenting its loss. The shift did not come from an argument. It came from the record. What had been treated as a routine encounter began to look different once it was reviewed frame by frame. Body camera footage captured the spacing, the tone, the timing, the pauses where questions were asked and not answered, the moments where commands replaced explanations. None of it dramatic, all of it precise. The footage showed the judge remaining inside her home, never advancing, never raising her voice. It showed the officer occupying the threshold, narrowing space without crossing it, asserting presence without articulating cause. The camera recorded repetition where justification should have been. It recorded escalation without provocation. Audio mattered as much as visuals. The officer's statements shifted over time. Early language suggested a request. Later language implied obligation. The transition was gradual enough to feel natural in the moment, but unmistakable in review. Investigators would later note the absence of a clear point where lawful detention was established. Dispatch logs added another layer. No call for service described a crime involving the judge. No report suggested exigent circumstances. The officer had initiated the contact on his own discretion. That discretion carried limits the footage showed were exceeded. Radio traffic revealed something else. When additional units arrived, they accepted the framing already in motion. Questions were asked about compliance, not cause. No one requested clarification of the legal basis for detention. The assumption of authority had become shared. Witness statements from neighboring residences reinforced the same pattern. Calm voices, no threats, no urgency. The environment remained unchanged from start to finish. The escalation existed only within the interaction itself. From a procedural standpoint, the evidence aligned. The detention was not supported by reasonable suspicion. The demand for identification preceded lawful authority. The refusal to explain the basis for commands violated standards the officer had been trained to follow. None of these findings required speculation. They emerged directly from the record. What made the reversal unavoidable was consistency. The judge's account matched the footage. The footage matched dispatch data. The data matched policy. Each layer reinforced the others. There were no gaps large enough to reinterpret. Internal review documents reflected the same conclusion. The encounter could have ended at multiple points. Each missed opportunity compounded the error. By the time detention was declared, the legal footing had already collapsed. The officer's initial report attempted to frame the escalation as necessary, but timelines contradicted it. Language did not align with footage. Assertions of non-compliance did not match what was recorded. The report became evidence itself. This is where power changes hands quietly. Not at the scene, but later, when authority is measured against documentation it cannot alter. The camera did not accuse, it did not editorialize. It simply preserved. Once reviewed, the outcome no longer depended on interpretation. The facts had already settled the question. What initially appeared to be a single misjudgment did not remain isolated for long. As the investigation widened, reviewers began to examine the officer's prior encounters, not because of speculation, but because procedure required it once a constitutional violation was identified. Patterns are not assumed. They are documented. The records revealed familiarity, not with criminal behavior, but with discretionary stops that followed a similar trajectory. Encounters initiated without clear cause, requests that escalated into commands, detentions justified after the fact rather than before. None of these incidents, on their own, had triggered formal discipline. Each had been resolved internally, quietly. Supervisory oversight became a focal point. In multiple prior incidents, reports had been approved without clarification of reasonable suspicion. Language was accepted as sufficient even when it lacked specificity. The absence of challenge functioned as approval. Training records showed that the officer had received instruction on constitutional limits. The policies were not ambiguous. The standards had been presented repeatedly. What was missing was enforcement. Deviations were documented, but not corrected. Internal communications exposed a procedural gap. When discretionary encounters escalated, there was no mandatory review at the supervisory level unless force was used or a complaint was filed. Authority could be expanded incrementally without triggering scrutiny. This is how systems fail without collapse. The rules remain intact. The training exists. The policies are written. But the mechanisms that ensure compliance do not activate unless the outcome becomes impossible to ignore. The judge's case made that outcome unavoidable. Because of her role, the review did not remain local. Federal oversight was triggered automatically. The same standards applied to her encounter had been applied by her in court for years. The analysis followed familiar steps: jurisdiction, authority, cause, documentation. Each was evaluated without deference. The findings did not accuse intent. They did not rely on assumptions of bias. They focused on process, on what was done, on what was not done, on where discretion had exceeded its bounds. That focus mattered. It shifted accountability away from personal disposition and toward institutional tolerance. The issue was not whether the officer believed he was acting appropriately. It was whether the system allowed that belief to operate without correction. Department leadership was required to respond, not to public opinion, but to documented failure. Policy revisions were drafted. Training modules were updated. Supervisory review thresholds were adjusted. These measures acknowledged what the record already showed. The safeguards had existed, but they had not been applied. The officer was not the only subject of review. Supervisors who had approved prior reports were examined. Internal affairs procedures were reassessed. The failure was distributed, not singular. This reframing changed the narrative. It was no longer about one encounter at a doorway. It was about a system that permitted authority to function without immediate accountability, relying instead on outcomes to reveal error. The judge's case did not create the problem. It exposed it. By the time the findings were finalized, responsibility could no longer be confined to a single name. The record showed how ordinary discretion, when left unchecked, becomes institutional behavior. And once institutional behavior is documented, the response moves beyond discipline. It becomes structural. The legal consequences did not arrive quickly. They arrived methodically. Once the investigation concluded, the findings moved through formal channels that do not respond to urgency, only to sufficiency. Evidence was reviewed, statements were compared, policy was measured against conduct. Each step reduced the space for discretion that had defined the original encounter. Administrative action came first. The officer was placed on leave pending disciplinary review. His authority was limited. Access to systems was restricted. The process followed established procedure, not because of the profile of the victim, but because the record met the threshold that policy required. The documentation left little room for alternative interpretation. Termination followed, not framed as punishment, but as consequence. The justification cited repeated deviations from constitutional standards, failure to articulate lawful cause, and conduct inconsistent with departmental obligations. The language was restrained. The outcome was not. Certification review was initiated at the state level. Standards boards do not assess intent. They assess fitness. The findings from the investigation were sufficient to revoke eligibility for future law enforcement service. The decision removed the possibility of transfer or reinstatement. Civil proceedings proceeded on a separate track. The lawsuit did not allege malice. It alleged violation. The pleadings relied on the same evidence already preserved: body camera footage, dispatch logs, training records. Each document narrowed the issues before they reached a jury. Settlement negotiations reflected that reality. Municipal liability was assessed not only for the actions of the officer, but for supervisory failures that had permitted the conduct. The amount was substantial. It was approved without trial. The city acknowledged exposure without contesting the facts. Criminal review followed. This stage required a higher threshold. Prosecutors evaluated whether the conduct met statutory definitions under federal law. The analysis was precise. Authority exercised without lawful basis. Deprivation of rights under color of law. The elements were examined individually. Charges were filed after that review, not announced with spectacle, not accompanied by commentary, filed in court, supported by the same record that had guided every prior decision. The maximum sentence reflected the seriousness of the violation, not the identity of the victim. Throughout the process, the framing remained consistent. Findings were attributed to conclusions reached by investigators. Actions were taken pursuant to procedure. No statement declared guilt before adjudication. The system moved as designed once activated. For the judge, the outcome was not vindication in the emotional sense. It was confirmation that the standards she had enforced from the bench were not symbolic. They applied outward as well as inward. The law did not recognize status. It recognized facts. For the officer, the consequences were final. Authority removed. Career ended. Exposure to criminal liability established. The path back did not exist because the record did not allow it. The law had not acted quickly. It had acted conclusively. The case did not conclude when the sentence was entered or when the settlement was finalized. Its effect continued in quieter ways, through procedures that rarely attract attention but shape how authority is exercised afterward. Policy revisions adopted in response to the findings altered how discretionary encounters were reviewed. Supervisors were required to document the legal basis for detentions earlier in the process. Thresholds for intervention were lowered. The absence of force was no longer treated as an indicator that escalation required no scrutiny. Training programs were updated to emphasize boundaries that had been treated as flexible. The distinction between requests and commands was clarified. Officers were instructed that refusal, by itself, does not transform into suspicion. These were not new principles. They were reaffirmations placed back into operational focus. The case also influenced how similar encounters were evaluated in court. The documentation created a reference point. Judges cited it when assessing credibility. Attorneys referenced it when arguing suppression. The record demonstrated how escalation can occur without intent, and why intent is not the standard that governs constitutional limits. Public discussion followed, but it did not drive the outcome. The decisions had already been made through process rather than pressure. The reforms were not framed as concessions, they were framed as corrections. For the judge, there was no return to anonymity. Her role in the case became part of a public record she had spent years interpreting for others. The experience did not redefine her authority. It underscored it. The law had functioned as written, even when applied outward. For the system, the case served as a reminder rather than a rupture. Authority remains conditional. Discretion remains bounded. When those limits are ignored, the consequences are not immediate, but they are durable. There was no dramatic restoration of trust. There was documentation. There were standards. There was precedent. These are the mechanisms through which accountability persists after attention moves on. The encounter began at a doorway, ordinary and unremarkable. It ended with changes that would outlast the individuals involved, not because of outrage, but because the law recorded what happened and refused to forget it